लोकसभा की कार्यसूची की बात की जाए तो आज मंत्रिपरिषद में अविश्वास का प्रस्ताव पर मंगलवार से शुरू हुई चर्चा को आज आगे बढ़ाया जाएगा। सांसद गौरव गोगोई ने 8 अगस्त को प्रस्ताव पेश किया था कि ये सभा मंत्रिपरिषद में अपने विश्वास का अभाव प्रकट करती है। आइए अब नजर डालते हैं लोकसभा में आज विचार तथा पारित किए जाने के लिए प्रस्तुत होने वाले विधेयकों पर। अधिवक्ता संशोधन विधेयक 2023 द एडवोकेट अमेंडमेंट बिल 2023 को पारित करने का प्रस्ताव केंद्रीय विधि एवं न्याय राज्य मंत्री स्वतंत्र प्रभार अर्जुन राम मेघवाल करेंगे। विधेयक के माध्यम से अधिवक्ता अधिनियम 1961 में संशोधन किया जाना है। विधेयक के अगर हम ऑब्जेक्ट्स और रीजंस की बात करें तो अधिवक्ता अधिनियम 1961 का 25 कानूनी प्रैक्टिशनर्स से संबंधित कानून को संशोधित और समेकित करने और बार काउंसिल और एक अखिल भारतीय बार के गठन का प्रावधान करने के लिए अधिनियमित किया गया था। आजादी से पहले ब्रिटिश संसद द्वारा पारित भारतीय उच्च न्यायालय अधिनियम 1861 ने क्राउन को लेटेस्ट पेटेंट द्वारा भारत में उच्च न्यायालय स्थापित करने में सक्षम बनाया। इन लेटर्स पेटेंट ने उच्च न्यायालयों को अधिवक्ताओं और वकीलों के नामांकन के लिए नियम बनाने के लिए अधिकृत और सशक्त बनाया। स्वतंत्रता के बाद भारत में न्यायिक प्रशासन में बदलाव की आवश्यकता के अनुरूप विधि आयोग को न्यायिक प्रशासन के सुधारों पर एक रिपोर्ट तैयार करने का काम सौंपा गया। फिलहाल संसद में आज में इतना ही। तो बने रहिए संसद टीवी के साथ। मुझे दीजिए आज्ञा। नमस्कार।
कुछ ही दिन पहले मैं मणिपुर गया। हमारे प्रधानमंत्री नहीं गए, आज तक नहीं गए, क्योंकि उनके लिए मणिपुर हिंदुस्तान नहीं है।
एक भ्रांति देश भर की जनता के सामने फैलाई गई है कि यह सरकार मणिपुर पर चर्चा के लिए तैयार नहीं है। मैं आज भरे सदन
Users can upload their proof of identity and capture their live photo during the registration process. They can also receive broadcast messages for important announcements or special arrangements. The e-passes are delivered to users through the email and Suswagatam portal. Users can scan the QR code on their passes at the entry and exit gates of the court premises. The portal also generates statistics on the number of e-passes issued and used. The Suswagatam portal was tested as a pilot project since 25 July 2023 and has received positive feedback from the users. As of 9 August 2023, more than 10,000 e-passes have been issued through the portal as a pilot. The Supreme Court of India hopes that the portal will enhance the convenience and efficiency. Information about the Suswagatam portal, one can visit the website or contact the reception office. And we're also having a video tutorial. So if people still want a video tutorial, they can see it. The video tutorial is presently in English. I said we must also have it in Hindi and other Indian languages. And for lawyers who want some help in the first time registration, just for the first time registration, they can go to the facilitation, the E-Seva Kendra on Bhagwandas Marg, which is at the entry point of the Supreme Court. So now we'll go from...
The entire nation would be grateful. But why I say this, we used to come when we didn't get those cards, which permits us to access. We used to come at 9 o'clock to stand in queue so that by 10:30 we get the pass and we can enter. Some 12, 13 years back, I'm saying. And that continued till date.
There's one aspect where my interns after the lockdown are still not being allowed in.
We'll see what
Some limit
I know, I'm
place that 2 interns per senior,
conscious of it.
because they are being denied the opportunity to see how the court works.
It's been
I think
okay.
that's
Your
not,
I've already
Take a look
been,
at
I've been in conversation with the staff on this specifically.
that's only for Monday, Friday, not other days, because of the rush on these two.
All right, let's get started now with Article
Can I only say
371.
that, we light a lamp in honor of the initiative.
Thank you. I must also inform the members of the bar that we've made efforts to ensure that the lead time between the filing of a case and the first hearing is curtailed to the minimum. So I keep a watch on how many matters are released for mentioning. So about 230, the figure is about 230 new matters are cleared by the registry every day. But I've done one more thing, which is I've disbanded the section which was dealing with transfer petitions. Now bifurcated transfer petitions to the separate sections dealing with that state. Transfer petition coming from Maharashtra before goes to the Maharashtra section, UP goes to the UP section. That staff of almost 20 officers has now been sent to section 1B, which deals with filing of fresh cases. So with 20 more hands now of our officers dealing with 1B, I think the lead time for getting a hearing in the court will be cut down even further. It was about 3 to 4 days. We'll cut it down even further. And as a result of this, and 1B, we have said that this staff will be bifurcated into staff which is dedicated exclusively to e-filing. Then second, for staff which is dedicated to physical filing, because we are still permitting physical filing. And third, staff which does our part of the back-end work, namely printing of paper books for judges who require printed paper books. So I think we'll be able to reduce the lead time in the actual date of hearing from the filing of a fresh case even further. Yes, Mr.
With only one suggestion, if Lord should also have a watch behind the back, so that the advocate will also know how much time he has taken. If your Lordship are able to see it there, we need a watch there as well. We can't see behind how much time is taken.
Incidentally, I don't know how mobile numbers travel. I get so many WhatsApp messages from people I don't necessarily know. One of the suggestions was, why do so many lawyers have to stand behind the arguing counsel? Because they said, is the arguing counsel not disturbed by so many lawyers standing right behind them? So that's something which, of course, is a matter of a voluntary compliance by the lawyers to let the space be a little open for those who are arguing. And of course, those who are assistant can sit next to the counsel who is arguing.
On the lighter side, apropos Mr. Shah's request, there should be a clock on the back. But for some of us, we need a calendar on the back.
Including the learned LG.
Time.
Including the learned LG.
Yes, sir.
We're not
I
going to
said, sir, for some of us.
How long we have been arguing?
Yes, Mr. Shah.
One clock would be there. That's all I'm talking about. May I begin, my Lordship? Yesterday I simply stated few things, which was by way of an introduction. I said that
I realized that I didn't say it. I realized why there is a crowd there.
to sit for seniors council as well. yesterday I submitted that after the independence of this country, the native states all became free. They became sovereign unto themselves. I also submitted that in the matter of accession to the dominion of India, they all entered into various kinds of agreements, which were, as law declared by this court, is an act of state between the two independent entities, the dominion of India on the one side and the native states on the other side. I also submitted that the relationship between these native states and the dominion of India was determined by the documents which were executed. In the case of state of Jammu and Kashmir, I also submitted that it was only instrument of accession which was executed between two entities, the dominion of India and the state of Jammu and Kashmir. Making that as the base, that would be the relationship between the dominion of India and this entity. Subsequent to this, when the residuary sovereignty vested in the king, further documents were to be executed relating to this particular state. The Maharaja issues the proclamation of 1948. In that proclamation, he says that we need to have a national assembly to frame a constitution. This is the genesis of framing of the constitution of Jammu and Kashmir is rooted in the nature of instrument of accession as well as the proclamation of 1948. That's where we arrive the source as to why second constitution for the state. Then the third thing is that after these declarations are made and no further documents are executed, but at the same time the Constitution of India was being made. So the problem and the issue, the question before them was what is to be done. This is what I said yesterday. And I also submitted that meanwhile, some more developments had taken place, which had an external dimension, which also shaped and influenced the Constitution Assembly of the Union of India. Now, this is the whole scenario which existed before Article 370 was adopted. And I also submitted that the residual power came to be subsumed by Article 370. My Lord's observation was what happened to instrument of accession. But subsequently, when you agree to a constitution, you had acceded to the dominion of India, maybe partly only, may not be fully, you had not integrated, I would say, because you had not executed merger agreement. So the Article 370 subsumed this remaining power, whether we call it sovereign power, residuary power, but it retained the power with itself. And therefore, next question would be the exercise of this power. Whereas the power is there in terms of the instrument of accession, now in Article 370, how it was to be exercised. I will make a digression here. Perhaps at that point of time, it was felt that since we don't have a Maharaja any longer, we don't have any other authority to do it, who would go in almost like a substitute for merger agreement? If complete integration had to take place, how could this be brought about? A mechanism is evolved in 370 that will be entirely for the people of Jammu and Kashmir to integrate with India. Whereas they have done it with accession, they have acceded to Union of India, but to integrate it completely, as I said, shaking hands and embracing, the embracement was left to the people of Jammu and Kashmir, but in accordance with the mechanism and the procedure prescribed by Article 370. What kind of power the Maharaja has retained? Most important was the power to make laws, which I said yesterday. Therefore, Article 370 itself says all other provisions of the constitutions are excluded. Notwithstanding, all provisions are excluded except Article 1 itself and Article 370. Everything else is excluded. Nothing else applies to the state of Jammu and Kashmir. The first part, as I come to that, I'm just developing this point for lots of consideration. The first part of Article 370 talks of application of laws in list 1, could be list 2, list 3. It talks of application of laws. Now that application of laws subject to one condition, that since I had donated some power earlier under instrument of accession on 26th of October, like defense, communication, foreign affairs, so there was no further donation required. Therefore, the word consultation was mentioned. Simply consult. Consult does not mean agreeing. You just have to talk to somebody in normal language also. The consultation, you talk to somebody whether he agrees or disagrees, but the dominant person would go in his own way after talking to him. But for application of it, the word concurrence was required. Now, there's a fundamental difference in consultation and concurrence, where both have to be ad idem, both have to agree. And both have to agree. They have to agree in respect of the entry under which the parliament had the power to make laws. But at the same time, you cannot have an extension of a law made by the parliament unless the relevant supporting provisional constitutional entry, being provision, is also made applicable. It is not conceivable that the parliament would have a law A, but there is no supporting provision of the constitution applicable to the state of Jammu and Kashmir, which would support extension of that law to the state.
Yes.
So there were limitations provided in 370 itself with regard to the power of the parliament to make laws for the state of Jammu. First limitation was if you are relating any subject to list 1 or list 3, which is not a subject covered by instrument of accession, then you need concurrence of the government of the state. Concurrence of the government of state would mean, in simple language, concurrence of the people of the state through Council of Ministers. Why was this needed? More on the question of why of Article 370. Why so special provision for state of Jammu and Kashmir? Only for one simple reason, that there was no merger agreement. That's the most important fact in the whole case. And therefore, this autonomy had to be maintained. The state found a way to maintain its constitutional autonomy, restricting the power of the parliament to make law, both in respect of various entries as well as in the substantive provisions.
Yes. Yes.
Even with regard to this, the substantive provision of the Constitution of India which was to apply, there is further restriction in that. It again has to be done with the concurrence of the government of the state. So we are at two places. One, when you want to apply any entry, you need concurrence. When you want to apply any constitutional provision, you need concurrence. Except in respect of what is mentioned in instrument of accession. छोटी की बात ना Super. Just support my point by the very text of Article 370. Notwithstanding anything in this constitution, the provision of Article 238 shall not apply in relation to the state of Jammu and Kashmir. The power of Parliament to make laws for the said state shall be limited to those matters in the union list and the concurrent list, which in consultation with the government of the state are declared by the president to correspond to matters specified in the instrument of accession governing the accession of the state to the dominion of India, as the matters with respect to which the dominion legislature may make laws for that state. Now pause here. It may not, what in simple language it says is that if what is mentioned in instrument of accession, somebody will have to agree that the entry mentioned in instrument of accession corresponds to any of the matters in the union list or concurrent list, and the President of India is to declare that such an entry corresponds to that list, then only the Dominion legislature will have the power to make the law. It is not straightway that we agree to the entry and they extend the law. It has to be in consultation, and the President has to almost declare it that it corresponds to the matter specified in the instrument of accession. For that consultation, the government is required. So it means it involves the President of India on the one side, and second is the government of the Jammu and Kashmir. Two are involved in this, government of the state. And then the third constitutional authority is the President, who is to declare that this matter specified corresponds to the subject of instrument of accession. Now, this is only in respect of union list and concurrent list. See the second part. Such other matters in said lists, that means union list and concurrent list, as with the concurrence of the government of the state, the president may by order specify. So here requirement is with the concurrence of the government of state, and the president is to specify in the order that matters other than instrument of accession, whether they can be extended, if so, only after obtaining concurrence of the government of the state. This is another limitation with regard to the power of the parliament to make law. Why is this? What is the need of this? Parliament has the plenary power. They can make any law under list 1 and apply it throughout India. Despite having acceded to the Union of India, despite being a part of Union of India, the mechanism was different only because it had subsumed the residual authority which the Maharaja had. Now this carves out the space for what we are contending here, why we are before the lordships. What is the whole case about? We'll take a lordship's time, the 5 learned judges are hearing this matter. It's only because we believe that we had constitutional autonomy. Under the Constitution of India itself, certain autonomy was available to the state of Jammu and Kashmir, which was taken away on 5th and 6th of August. We're here contending that you cannot take away that autonomy of the state. This is all what the whole case is about. Now, I'm trying to lay down the basis. Where does this autonomy come? This autonomy comes from the instrument of accession is one. And second important thing is Article 370 itself. It doesn't give power to the institution of parliament to make any kind of a law it wishes to make for the state, unless the state government agrees to it. And both by consultation and concurrence. For the purpose of this article, the government of the state means the person for the time being recognized by the President of Maharaja Jammu and Kashmir, acting on the advice. I'll make these submissions later. But what I'm trying to show is this important about D. Such of the other provisions of this constitution shall apply in relation to that state, subject to such exceptions and modifications the President may by order specify. Now, this part relates to the constitution itself. The earlier part relates to the lists. That's the power to make the law. But this clause D does not talk of the power to make law under the lists. It talks of the provisional provisions of the Constitution of India as such. Giving power to the president, you apply the provision of Constitution side. But in order to maintain the constitutional autonomy, power is also given to the government of the state, that you can request the president, please apply this provision with this modification, with this exception, with this omission. How that is to be done, that is between the two governments. That's between the government of the state and the federal government, the central government. That's between them. That could be a political decision with which the court is not concerned. But constitutionally speaking, there is no power vested in central government or in president to make any law as they wish, as they do it in the case of other states. No consent is required from the other state. No consultation is required from any other state. No concurrence is required of any other state, except of one state, that's state of Jammu and Kashmir. This is the second part which will demonstrate to my notes that how the constitutional autonomy of the state is embedded in Article 370. And sir, the two provisos, provided that no such order which relates to matters specified in instrument of the state referred to paragraph so and so shall be accepted in consultation. The same thing as list 1 or list 3, you need consultation if they conform to the instrument of accession. Second provision, but provided that no such order which relates to matter other than those referred to in the last preceding proviso shall be issued except with the concurrence of the government. So concurrence is needed for the application of these constitutional provisions. They may as such apply, entirely up to the two governments to agree to that. They may apply with the modifications entirely up to the two governments. They may apply with exceptions entirely up to the two governments. Then, sir, if the concurrence of the government of the state referred to in paragraph 1 of so and so or the second provision so of that clause be given before the Constituent Assembly for the purpose of framing the Constitution, this is again a very important expression used, that while the Constituent Assembly of the state is framing the Constitution and you have given this concurrence, while it is in the process of framing the Constitution, then you will have to place that concurrence before that Constituent Assembly. And with jurisdiction on the Constituent Assembly to agree or disagree with that concurrence. That is what is significant. For such decision as it may take thereon. So in real practical terms, up to 1957, when the state adopted its own constitution, during that period, if at all any concurrence at any stage or any consultation at any stage had been done, it was to be placed before the Constituent Assembly of the state. And what's important is that the Constituent Assembly of the state could invalidate that concurrence or that consultation when it says, for such decision as may take thereon. Then, sir, is the clause with which we are concerned and which has been used. I'll make this submission later, but I just read it right now. Notwithstanding anything in the foregoing provision of this article, the President may by public note declare that this article shall cease to be operative or shall be operative only with such exceptions and modifications from such as he may specify, provide that the recommendation of the Constituent Assembly of the state referred to in clause 2 shall be necessary before the President issues such notification. When we read this clause, this is different from the clauses which are preceding it. And this clause carves out a position for itself when it says, notwithstanding anything in the foregoing provisions of this article, which will be the earlier, the union list, the concurrent list, consultation, or the provisions of the Constitution. Notwithstanding that, the power is given to the President to, this is one of the issues involved in this case. Can we say he has de-operationalized it or has he amended it? The expression used is declare that the article shall cease to be operative or shall be operative only with such acceptance. So the President is given the power to de-operationalize this article. Therefore, a distinction between Article 368, which my lords observed, that had nothing to do with 370. It's a case of de-operationalization of Article 370, subject to the method, the mode, and the requirement of subclause 3 of Article 370. I'll have something more to say on that, but right now, the point which I was making was that the states being free ये मैं तो बता ही रहा कभी करता था
The constitution as it applies to the state of Jammu and Kashmir, which is the entry relating to Jammu and Kashmir? Because, the book we have now has the latest, after the 2019, they delete they never give you footnotes. And I was trying to scroll down in what is the original entry when it came in? What did the entry say? The entry in the first schedule to the constitution relating to Jammu and Kashmir?
in 1950.
Or soon thereafter. How was that paraphrased actually?
I worked on that also. I have the copy of the original constitution. It was passed in 1949, 26.
Right.
I have that. What was the situation at that point of time? One. And number two, 1954.
Right.
When that first order came.
The first order.
There were two before. 1950 and 1952. Both
Yes.
were superseded by 1954. I'll take a lordship clause by clause that what was contained in that 54 order and as well as what was contained in the original constitution when it was passed. We need to go back in time. Without that, it's not possible to apply certain standards as we understand in 2023. This is the situation which has its roots in history. And we have to know why, how and why of if we need to recognize and appreciate how and why of Article 370. Why 370 in the first place? Simply it's a historical process, or there were certain compulsions, there were certain constitutional issues involved, because these were between the two states. It was in the nature of an act of state. Why this Article 370? The Lordship needs to understand this Article 370. It is source. And then sort of if I am to say so, sort of a compromise. On the one hand, you said there is no merger, it is not completely integrated. This is one aspect of the matter. The other aspect of the matter is pending as it is. Third aspect is that between the two governments found, okay, you stay with us. You stay with us, but we will grant you some autonomy. These are all provisions related to this autonomy. Of course, in terms of 54 constitutional application orders which have been passed, right after 1957 till the last one, 2019, gradually the government of the state has been, if I use that expression, chipping the power of the state legislature. Now, what does it mean when I'm saying so? My legislature in 1950 had the total power of making laws except three subjects. So I could make law on any subject, whatever I liked, because that's the power vested in me in 1950. But what happened subsequent to Article 370? The state government is given the power under 370. Look here, you can concur with the Union of India and request them, please apply this entry. Good. When you apply that entry, what are you doing and who is doing it? It is the government of the state which is doing it and taking away the power of the legislature of the state to legislate. Otherwise, that power was with me.
But Mr. Shah, all that must have been done with either the consultation or with the concurrence of the state legislature or state government.
Sorry, sir.
No, all this must have been done either in consultation with the state government or in concurrence with the state government.
I'm saying so. I said it resulted in, that's what I'm saying so. 54 constitutional orders which were issued, they were done in concurrence, in consultation with the government. The other flip side of it is that our state legislature continuously lost power to legislate on those subjects, wherever they agreed. I'm not sure the question of wisdom, why they agreed or why they didn't. I remember, just suppose what is left in Article 370, you have gradually donated all the power to the Union of India. That aspect is there. But I'm saying in the original intention, what was the original intention of the constitution makers?
So could it not be gathered from
original intention?
Could it not be gathered from sub-article 3?
3.
That the constitution makers.
That one?
Yes, sub-article 3 of 370.
3 of the
370. That the constitution, that the framers of the constitution themselves at that stage conceptualized that at one day the provisions of
Oh, your is not audible.
That subclause 3 envisages by a process in a given situation that Article 370 would be de-operationalized, to use your phrase.
Yes.
The process is a separate thing. Therefore, to say that 370 has such a permanent character in the Constitution that it can never be amended would be, it's a very, very difficult proposition. Because suppose the state itself had said, that's why to Mr. Sibal also I posed the question.
Yes.
Suppose the state itself says that we want all laws to apply to 370. Then where does 370 go, apart from the chipping issue which has occurred over a period of time? So then we will really come back to the process. Was this the process permissible or not? That would be the question. That's how I look at it.
Yeah. We might have different perceptions of it, but let me share my perception with the lordships. If we don't want Article 370, answer to this question will first depend on, as on today, on 5th of August 2019, was it still temporary, or because of the passage of time, non-availability of the machinery originally contemplated by Article 370, had it become, despite being in Part 21, showing temporary, marginal load showing temporary, it had become permanent. Permanent in the sense because the machinery was not available to remove it. Now, I'll just clear it more.
Testing this proposition, Mr. Shah. Suppose that machinery was to be created, can it be removed? Is your argument that it? See, when you say it has acquired a permanent character, if the machinery, which according to you is the appropriate machinery, and which did not exist for 370 to be available.
Yes.
If that machinery was to be recreated or created or in existence, then 370 could be removed.
Yeah, if that machinery was recreated, that is Constituent Assembly recreated. But which Constituent Assembly? Please see at subsection 2. Just for I am aware of a lot of observations my lords are making. Please see it as subsection 2. And I would seek your lordship's consideration also on that. If the concurrence of the government of the state referred to in paragraph 2 of subclause B of clause 1 or in the second provisional subclause D of that clause be given before the Constituent Assembly for the purpose of framing the Constitution. So it is identifying which Constituent Assembly they are talking of. And please go back to subclause 3. Notwithstanding anything contained in the foregoing clause of this article, the President may by public note declare that this article ceases to be operative or shall be operative only with such acceptable modifications and provided that the recommendation of the Constituent Assembly of the state referred to in clause 2. Referred to in clause 2. Today, if your lordship were to direct a you form a Constituent Assembly, my humble submission would be
a little different. I am saying, suppose as COs have been issued from time to time, and according to you, by concurrence of the state government or the assembly, were there an assembly, was there a state government which says that all the provisions of the constitution will apply? What would be the scenario?
When our state government says all the provisions of the Constitution will apply, they will say so how? Outside 370 or within 370? They have to say so that only through 370.
Right.
That is the route.
That's the route. So
Yeah.
therefore, once they are able to say so under 370, except that 370 remains in form.
Yeah, then it remains a form. It remains a skeleton. Very true.
It's just a shell.
But the root is one. What's important is root is one.
So
If you take away 370, let us take away 370.
even now, in a sense, 370 is not removed in that sense. What has happened is that whatever remained of 370 inside, in their wisdom or lack of it, whichever way you may put it, they've utilized the machinery of 370 to remove whatever was left in 370. That is what has happened.
Kindly appreciate. First of all, who can remove 370 is one question. The Lord's observation is that if the government of the state.
Process we have not come to. Process is separate. You have an argument on that look, this is not the process by which it could have been done. That's it.
Now, if you wanted to do it completely, aren't we going back to the original position? If you want to completely integrate, then we have to get rid of 370. We have to get rid of instrument of accession, which said 3, then we have to execute merger agreement. Because I was an independent state. We go back to the roots.
The roots, Mr. Shah, you rightly said over a passage of time, the merger agreement, the 370, there were developments which took place, historical developments. Then after that, 370 came, it was to govern. Then over a period of time, different matters, as you say, chip by chip, 370 was the effectiveness of 370 in terms of preserving the right in the states to lay down the law was chipped away over a period of time.
Yes.
Something still remained.
Yes.
That something which still remained, they did it by a process of 370. Whether that process was right or process was wrong is the second limb of the argument, that they could not have done this or they could have done this in this manner. So they have also left now still a 370, but effectively making all laws applicable. So my only query is that doesn't it all come down to one thing, whether the process they followed to do so was flawed?
Leave the process aside for a minute, Lords. I am one of the federating units. I want to be with the Union of India. 370 as it is it in the nature of an obstacle to integrate myself with Union of India? If it is an obstacle, then obviously somebody who thinks that this should not be an obstacle, you must integrate fully like any other state in India. Then he has to first, constitutionally speaking, not politically, he has to get rid of 370 as it is. That's it one.
Again, this goes contrary. Mr. Gopal Subramanian's argument was, this is a medium of interaction, 370. It's a medium of interaction. Therefore, that's the process you must follow. Now, if we go back historically to say that it has to be abrogated, we must go back to the original, then how does it merge with it? The only thing is that under 370, which is the medium of communication between the center and state, which was established. We established a methodology by which slowly, if you wanted, you could do it. Now, once that is there, it has been done. Historically also, if we see, it has been done over a period of time. Something still remained, as I said, at a cost of repetition. Now, that what remained, they took away by a similar kind of a process as what was being done earlier, but the process is said to be flawed because there was no assembly, there was no elected body in picture. That's the only question I had.
Shah, just one more thing.
Yes,
If one looks at subclause 2,
yes.
now it says that if there is any agreement with regard to subpara 2 to subclause B to clause 1, or in the second proviso to clause D to clause so and so, then the Constituent Assembly will take a call on it. Correct? Now, the Constitution of India, if one looks at Article 1, which is specifically incorporated in the Constitution of India, it says, India, that is Bharat, shall be union of states, states and unit entities thereof shall be specified in the first schedule. So the question of merger being complete is absolutely certain. What has been given over here in Article 370 is twofold. One is with regard to the union and the current risks, the right to make laws. They said there could have been even earlier a situation where some articles of the concurrent list or the union list could have fallen in the state list. But in this case, is case of state of J&K, which is merged with the state of, with the entire country, became part of the Indian Dominion. There's certain rights given to the state legislature to make the laws. That's all.
More rights, more rights.
More, yes, more.
In comparison.
Vis-a-vis the list in question, the right to make laws are given to the state legislature.
Yes.
But with one stipulation that the state legislature can, with the concurrence of the state legislature, those laws can, if the concurrence is given, then the central government or the Union of India can also make laws. One. Number two, with regard to the provisions of the Constitution against, with the concurrence of the state in question, gradually the laws can be, all the provisions of the Constitution can be made applicable. That's part one. Part three, that is clause 3, deals with abrogation of Article 370 or modification or changes in that. Your case, as far as proviso is concerned, what is the effect of the proviso is something separate. Is our understanding correct?
Yes, yes. Your Lordship is correct. The first part is with regard to union list, the making of laws, very true. The state legislature, my state legislature gets more laws. I will show that exactly the same position. It has more laws, more power as compared to in relation to other states in India. And why in relation to other states of India? As I said earlier, I raised one argument yesterday. I said they merged. When they merged, it is the Constitution of India which gave power to these state legislatures. It was open. I would go to the extent of saying it was open for the Union of India not to give any power. It could have made it totally unitary because they had merged. They had no personality of their own. Their statehood was lost with the merger. But government of the Constituent Assembly of India still agreed that under list 2 they will have the powers. That's the theory of separation of powers now, with different views of this honorable court, whether they are administrative in character, whether they are political in character. We're not going to that question. But with regard to Jammu and Kashmir, it was, as I said, concurrence. On my concurrence, he could do that. So I would give concurrence, they would make law. I would give concurrence, they would make law. This position would continue. Under D, position is the same. I would give concurrence, they would agree for constitutional provisions with or without modification. This power is there. Doesn't it come to your Lordship's mind that when this Article 370 was enacted by the Constituent Assembly, did they proceed on an assumption? This is what I'm important to say. Did they proceed on an assumption that this Constituent Assembly of the state of Jammu and Kashmir will recommend to the Union of India to do away with 370 so that it completely integrates? It could not have otherwise because of the instrument of.
I have some reservation on the use of the word completely integrates. Integration has taken place in terms of Article 1.
Integration, I said complete integration.
No, probably what clause 3 says is Articles 370, which is a special provision, can be abrogated, can be modified, and or made applicable exceptions. That's all. Integration is, as far as Article 1 is concerned, is complete.
Can we divorce it from the context? We're going simpliciter as on today. In 2023, it's easy to say so, sir, with respects that it simply says we can get rid of this Article 370 because it is flexible in terms of one part of clause 3. That's what my lords are saying. But it has a context. I'm more on the context. I can divorce it from the context in order to appreciate and understand it.
Anyway, please continue.
In that context,
You understood.
it cannot be done. Of course, if you divorce it from the context, then of course, just like your lordship is saying that this is temporary. Why are my lords saying it is temporary? Because part 21 says it styles itself as temporary, transient and special provisions. Therefore, it is temporary. Why did you put it in part 21? The marginal note of Article 370 says it is temporary. So therefore, on these two facts, my lord saying this is temporary.
You know, Mr. Shah,
Yes.
one thing which was very clear is that there was no conditional surrender of sovereignty to the dominion of India. The surrender of sovereignty was absolutely complete.
Yes.
And once the sovereignty was unquestionably and fully vested with the dominion of India, then the only restraints which would apply would be on the power of Parliament to enact legislation, so on and so forth. A few restrictions which remained, which were also then, as we have seen, subsequently modified. And in fact, in the Constitution Application Order of 1972, which is CO 93, which we'll find at volume 3, page 52, the very interesting provision which comes in 1972. In 72, Article 248 was amended in relation to its application to the state of Jammu and Kashmir. And 248 was substituted, which provides for residuary powers of legislation in respect of all other states. 248 reads with entry 97. Now it says Parliament has exclusive power to make any law with respect to prevention of activities directed towards disclaiming, questioning, or disrupting the sovereignty and territorial integrity of India. Therefore, the order of 1972 makes it now beyond the pale of doubt that sovereignty vested exclusively in India, and therefore no vestige of sovereignty was retained post the instrument of accession.
May I submit to lords of this?
Is it correct that Article 248 now applies, 248 as it is applicable to the state of Jammu and Kashmir immediately before 5th of August 2019, contains an absolutely clear and unequivocal acceptance of the sovereignty of India?
I may respond to my lord's observation. First is the instrument of accession.
3, page 52.
First, when there was instrument of accession, one legal question for my lord's consideration is this. When you accede, this was a general instrument of accession applicable to all the states. When you accede, do you transfer your sovereignty to the union or not? That is answered by this court, fundamental. They said no. You have not transferred your sovereignty in terms of only instrument of accession. You transfer it only by way of merger agreement. When I concluded,
What is superior? The Constitution of, sorry, what is superior? The Constitution of India?
Of course, it's Constitution of India. But there's no doubt about that.
Constitution of India is the merger agreement. The
Not merger agreement, instrument of accession. But with 370 in it. If it was no 370, it was different. My lords
ultimately,
understand your lordship's mind that one is Constitution of India is there. your instrument taxation goes, your sovereignty goes, your everything goes.
Ultimately, it's
But
C7.
it doesn't seem to be like that because this is something which has been there for 69 years. This is how the governments have worked it out. For 69 years, from 1950 to 2009.
Now take a case of an Indian state apart from Jammu and Kashmir.
Yes.
There are restraints on the power of Parliament to enact laws with respect to anything in the state list. Even today, Parliament can't and cannot enact a law on the state list.
No, I'm with
Right?
your lord.
Now, the reason I mention it is, these restraints on the power of Parliament are equally consistent with sovereignty, where all the other Indian states, in any case, vesting in the dominion of India, in India.
No, with
So
respect,
a
no.
restraint, see, the distribution of legislative powers does not affect the fact that sovereignty vests in India. So there are certain areas where the Parliament cannot touch something which relates to a particular state list item. But merely because Parliament is completely disabled from touching a state list item while enacting law, does that detract from the fact that all these states ceded sovereignty to the dominion of India? So what I'm trying to tell you is this, that restraint on the power to enact legislation is implicit in the scheme of the Constitution, the frame of the Constitution, because we do not have a unitary state. But does that detract the fact that Parliament cannot enact a law on a state list item? Does that detract from sovereignty? It does not. It's just a fetter on Parliament. But there are other fetters on Parliament as well. Now you have the goods and services tax, which is another fetter which has been brought in by consent of the states and by Parliament. These are all fetters which don't dilute from sovereignty. Likewise, once Article 1, as Brother Justice Khanna said, says India shall be a union of states, and that includes the state of Jammu and Kashmir. Transfer of sovereignty was complete. Therefore, we can't really read the Article 370 Constitution as somehow a document which retains some element of sovereignty in Jammu and Kashmir.
I'm saying so for a simple reason. The example which my lords gave, that there could be constitutional provisions with regard to other state legislatures that they can do, Parliament can make law, cannot make law with regard to that state legislature. Those limitations can be in the Constitution. But looking to Article 370, when it says concurrence of the government of the state, I say I am claiming it as a right of the state that my concurrence is needed. In the case of other states, where the Parliament may, as a matter of concession, say, look here, I will not do this for you, I will not do that thing for you. That's a matter of concession, not as a matter of right. I am claiming the state right, the state's right not to apply any law of the Parliament unless I don't concur with that law. I am claiming the right.
I'll tell you, there are provisions in the Constitution which apply to concurrence of the states also. See Article 249. Parliament can enact a law on a matter covered in the state list. And it says that concurrence is required. Just see 249. Notwithstanding anything in the foregoing provisions of this chapter, if the Council of States has declared by resolution supported by not less than 2/3 of the members present and voting, that it is necessary or expedient in national interest that Parliament should make laws with respect to goods and services tax came in recently, or any matter enumerated in the state list specified in the resolution. It shall be lawful for Parliament to make laws for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. That's how Parliament enacted a law for the Urban Land Sealing and Regulation Act. When the ULCRA came into force in 1975, it was preceded by resolutions by all the states because it was a state list item. So even on other states, Parliament has been given the power to enact laws on the state list, but it's subject to the concurrence. Here it's the Council of States, because the Council of States represents the state.
No concurrence required in this council.
It requires a resolution of the Rajya Sabha.
Resolution of the states. Choice is that of the states. Kindly see this. Not for anything under the folio. If the Council of State has declared by resolution supported by not less than 2/3 of the members present and voting that is necessary or expedient in national interest, that Parliament should make law with respect to goods and service tax provided under Article 246A or many matter enumerated in the state list specified in the resolution, it shall be lawful for Parliament to make law for the whole or any part of the territory of India with respect to that matter while the resolution remains in force. Now, it talks of resolution, maybe it also interprets that resolution as a consent of the state, but it has to be in national interest that the Parliament has to make.
Now see 252 for a moment, 252.
252.
If it appears to the legislatures of two or more states to be desirable.
Two or more states to desire that any of the matters with respect to Parliament has no power to make law, but except as provided in Article 242 should be regulated in such states by Parliament by law, and if a resolution to that effect are passed by all the houses of the legislatures of those states, it shall be lawful for Parliament to pass an act for regulating that matter accordingly, and any act so passed shall apply to such state and to any other state by which it is adopted afterwards by resolution passed in the house or where there are two houses by each of the house of the legislature of that state. Any act so passed by Parliament may be amended or repealed by an act of Parliament passed or adopted in like manner, but shall not, as respects any state to which it applies, be amended or repealed.
Therefore, though Parliament ordinarily does not have a law, does not have the constitutional power to pass a law with respect to a state on a matter which pertains to the state list, if two or more states come together and say that, look, we want Parliament to pass a law, here again there's a concurrence required of the state for two or more states. So in that sense, concurrence is not something which is unique to only the relationship with Jammu and Kashmir. There are various shades of concurrence required in the constitution. It doesn't reflect on the sovereignty of the union. These are fetters. Now you see 246A, when it came in, as a result of the goods and services tax amendment. This is a classical case where the government of India or Parliament can do nothing without the concurrence of the states. 246A has completely redefined our notions of sovereignty in that sense, because the states have now been given a vital role in financial matters. Parliament can do nothing unless there is a requisite majority in the Goods and Services Tax Council, the GST Council. So, in that sense, our notions of the parliamentary exclusive competence, the state's competence, that's itself been, Justice Kaul mentioned that yesterday, it's been an evolving exercise.
Looks like
one thing is very clear, sovereignty was ceded completely to the Union of India.
See, my lords, may I respond to my lord's observations? What my lord finds is that there are provisions in the Constitution
Yes, Misha.
What my lords are observing, which I understand, is that there are provisions in the Constitution where the states can also request the Parliament that you make the law for us, even if that subject of that law may be in the list too, where the state legislature had the exclusive power. But if two or more states decide so by way of a resolution, request the Parliament may make law for that. So it would imply that what is contained in Article 371, where it says that you will apply the law with the concurrence, it's in principle the same as there are other provisions, if I understand your lordship. So there is nothing so sacrosanct about it. I leave it for a minute. What about the constitutional provision for which concurrence is required and the president is to apply with modifications to me after that concurrence? Whether such a provision also exists for the states where they can request the President of India that you apply this constitution to us with these such kind of modifications, or it is not possible for the legislature to say so. So far as making of ordinary laws and so far as making of the constitutional provisions, obviously qualitatively they are different. In our case, concurrence is required also for the constitutional provisions, whether with exceptions and modifications, that will also be seen. So ordinary laws, maybe my lord finds the support that there are other provisions, nothing great about it. But nevertheless, that will go against the text of 370 when it says concurrence is required for purpose of list 1 and list 3. Whereas other provisions also provide that in a certain situation, not as a matter of routine, in a certain situation, the states can also request the parliament to make the law. In our case, it is not a matter of routine that they could do so. For every kind of legislation which has been passed at the request of the government of the state, concurrence has been given. So there is no general concurrence.
Yeah, you made the point
all this,
succinctly.
All the 54
applications. Should we go on to the next point now? Because we've understood your
submission. Let's go that also to allow just one more thing. Also that when these 54 constitutional orders have been passed, what is it that is given to us? And what was that was not given to us? In these 54 constitutional orders, which have been passed with a concurrence, there are some extremely important constitutional orders. Extremely important. Now, for example, take one. Article 3 provides for the alteration of the state's boundary, which has been read. I'm not dealing with that question, but I'm dealing it in a different way. For state of Jammu and Kashmir, you cannot do it. You cannot do it at all in terms of the 54 order. Why can't it be done for state of Jammu and Kashmir? The 54 order placed an embargo on it that till the state legislature will recommend for changing the name, for changing the boundary, you cannot do so. Now, this is a modification made in the application of Article 3 to us. Why was this kind of a provision made in Article 3? I cannot lose sight of the situation in which this Article 370A has come into existence. Now, I'll give one more instance, which is extremely important instance. Article 253 deals with the treaties which the government of India may have with foreign countries. But kindly have a look at the proviso to Article 253. I want you also to have a look at it and say why such provisions have existed in its application to us. 54 order. 54 order. अरे यार तेरे को पता ही नहीं होता है. 151 में है.
Page 150. Yeah, that's the we just told us volume 1 page PDF page 150.
Volume 1 of the documents compilation. 54 order.
Will it be there in volume 2 also, the constitution? No.
Actually, since we are just midway through the proceedings, if someone can just do this exercise, some of the leading, things which we are going to be constantly referring to, you can just prepare a little one-page index for us. Just not everything, just on one page. Things which now we know everybody is referring to it. So it just becomes very easy for us to...
several volumes, 6 volumes are there.
Yeah, but ultimately from the 6 volumes, there are about, say, 20 documents which everybody is referring to. Those, if you can put down on one page with the volume number, it just becomes easy for us. We can keep it on the dais and just flip through it whenever.
Volume 1, page number 54.
What that page?
The constitution sublimed to Jammu.
No, that is at, I think, page 13.
Volume 3.
It's page 13, that's right.
Page 13.
One may be here.
Volume
like
3, page 60.
COR, or you are referring to the constitution as applicable to the...
Bhushan, constitution is applicable.
Has all the learned judges got it or no? The Lordship has got it?
One is in the GO and the CO and the other is the constitution. It's the same. 151 मिल गया आपको ना? मिल गया 150.
Should I read it? Your Lordship got it?
Yes.
What does it say? Now, 253 deals with international treaties and agreements and conventions, provided that after the commencement of the constitutional application of Jammu Kashmir Order 1954, no decision affecting the disposition of the state of Jammu and Kashmir shall be made by the government of India without the consent of the government of that state. What is being recognized?
Disposition.
What's being recognized here? This is what I'm saying.
What is meant by disposition actually?
Final disposition, which would mean in 1954, the government of India concurs with the government of Jammu and Kashmir that the final disposition of the state of Jammu and Kashmir has yet to take place.
No, decision.
Read it once again.
Disposition of the state.
Sorry?
What is meant by disposition actually?
Not settlement. Disposition would mean settlement.
Yes, they agree, Lord. We can't say. Because in that context, it's all old story in the past.
This is in my humble submission. Of course, there are different perceptions of it. This is the recognition of that position which preceded enactment of Article 370.
It doesn't mean that all treaties will not apply to J&K. For instance, suppose the Universal Declaration of Human Rights or the Covenant on Civil and Political Rights, that would apply. Or say the Convention on the Elimination of Discrimination Against Women, that will all apply, right?
We're only on the point of the state's disposition.
The state's disposition.
Now, when we talk of state's disposition, I had already entered into instrument of accession. What does it mean that the state has yet to be disposed and will be done by Government of India only with the consent of the Government of Jammu and Kashmir? Where would it apply? This situation will apply where? This is concurred by both the governments. It's not unilateral action. I would submit this is the recognition of this submission which I made yesterday, that this issue has an external dimension which is recognized in this. It has an internal dimension which is also recognized in this. And both went together with Article 370, clearly carve out a position that state of Jammu and Kashmir has a distinct position pending it is disposition. Final disposition. What I am submitting is that this state of Jammu and Kashmir, all judgments of this court बच गए कितने हुए? बच गए कितने? टाइम क्या हुआ? हैं? 10 to 1. Yeah. छोड़ो ना, सामने थोड़े मांग रहे, आप नहीं बोल. So, Milords, the premises on which I am building up my case is this: that state of Jammu Kashmir, as all judgments of this court show, has a special and a peculiar position. It is for the first time this court is called upon on a very important issue, whether this can, the way it has been got rid of, whether it could have been done like that. And that does not involve any issue of the procedure involved. It also involves the issue of power. Isn't it something which is basic to all the arguments raised before this court with regard to the power? The power of parliament, the power of president, the power of the government of the state, the power of the governor. The common theme in all these constitutional authorities is the power. And we're examining that issue, we're debating that issue, that something has been done, whether you had the power to do so. This is one. Second, how did you exercise that power? And if the exercise of the power is unconstitutional, then even if you have that power, the action will still have to be invalidated. This seems to be the theme of the whole thing. Ultimately, whether 370 by itself subserves the sovereignty, as I said, it does. But at the same time, the sovereignty is exercised by it from time to time by agreeing to all constitutional orders, passed 54 in number. How those constitutional orders were passed, how they are passed, and what is the effect of those is also an issue. Then also, what is it that we are claiming? We're only claiming constitutional autonomy, which has been taken away from us on 5th of August and 6th of August. Now, how do we get that constitutional autonomy back? Is by demonstrating to the court that what is that I had If I had nothing, then what am I fighting for? It would be an unrealistic litigation, unworkable litigation. It will have no result at the end. Second would be I still had the constitutional autonomy, maybe little, maybe whatever it may be, as Honorable Justice Court observed, you are talking of a skeleton. Maybe it was a skeleton, but somebody still felt that skeleton was disturbing him, therefore he got rid of it. If it was a skeleton, leave it as it is. The way we were living prior to 4th of August 2019, then the things remain as they are. But then the thought of removing this skeleton, somebody must have thought somewhere that this skeleton must also go. But I am not on the question of this skeleton. I still had the power. Now let's see what was in the Constitution. What was the constitutional application, or in particular 1954? Why? Because it is that order which is amended from time to time. And then what was sought to be protected? Can I say something more, Millers? We are protecting, let's say, the individuals who live in the state of Jammu and Kashmir as permanent residents. Now that is protected under the Constitution as applied to us. I'm just saying that is protected. That was protected earlier also in terms of the notification of 1927. And interestingly, at that point of time, agitation was raised by a community, my lords. Unfortunately, they left us, and we owe a lot to that community because we were taught by that community. Anyway, that apart, they agitated because they were the educated class, and the king at that time would get people from Punjab and other areas. So they said, we need jobs. So they agitated, and that resulted in a notification of 1927 and restricted appointments to the permanent residents. That subsequently there was a notification 1932 that also restricted. Now, when that is protected, now it has protected for several reasons. One could be that, look here, it is meant for the jobs, it is meant for acquisition of the properties. Second also could be that, look here, the state as it is, so the people who live there need to have some rights, some privileges as against others. So they all protection came, that's one. Number two, state itself. Keep the state intact, though we are three regions. We are Ladakh region, Kashmir region, and Jammu region. The Maharaja at that point of time thought that bring all the three regions together, and then we became a state. To protect the whole state. Now what has been done? It has been divided. The people are divided. The part of it is with Pakistan, the part of it is with China. About 2,000 kilometers are with China in Aksai Chan. Part of it is with Pakistan, and remaining part is here. We're getting sandwiched between all these forces which are applying in the state of Jammu and Kashmir. Now, by virtue of this, again, the people have been divided now. Now we're reduced to a union territory of only Jammu and Kashmir, and Ladakh has been separated from us. Somewhere, somebody, when they say how to make a law, somebody was asked, a lawyer who was involved in how to make it, he told him, you tell me the political decision, I will tell you the law. Law does not precede political decisions. First, some politics comes in, then the laws come. So looking at the laws as they have been framed, somebody took these decisions to make divisions and further divisions to our state. Now we are claiming a position which it was on 4th of August. We need to be reunited with all the three regions. We need to live as we used to live. And then, of course, over the passage of time, as the government of the state, as I'm not on the wisdom of that, rightly or wrongly, government of the state from time to time did agree, did give its concurrence to the application of various laws from time to time. But nevertheless, there were some fundamental laws to which they have not agreed in the 69 years. Now, for the first time, now this proviso which is added to Article 3, this continues as it is. Now, entry 97, your Lordship just read. Entry 97 is the residual power of the Union Parliament. If any of the subject of legislation does not fall in all those 96 entries, but yet it will be covered by entry 97. It means it is open. If any legislation does not fall either in state list or concurrent list and is made by Parliament, it will fall in entry 97. When it is made applicable to us, it is made applicable to us in a specified manner. What is that specified manner? In 1985, the Parliament enacted Terrorist and Disruptive Activities Act, formerly known as TADA. That did not apply to us. The government at that point of time, I still remember 6th of June, 1985, it recommended to the government of India, please apply this entry 97, but restrict it to the matters which your lordship read just now, questioning the integration of the state, questioning the accession, so on and so forth. Please apply that entry. Accordingly, this entry came to be applied. It would imply that entry 97 as such, with widest possible power under entry 97, does not apply to the state of Jammu and Kashmir. It applies on a specified issue of a subject matter of a legislation. This, for example, I'm indicating another autonomy which I have. I have the autonomy of permanent residence. I had the autonomy of alteration of my state. I had the autonomy of final disposition. I had the autonomy of entry 97. Then there are similar other entries, both in the concurrent list as well as the list one. So I will give you a long list of the entries which apply to us with modifications. And those modifications carve out the constitutional position, the constitutional autonomy which the state enjoyed. Now, see another important thing. But the laws of this country obviously give rights to the citizens of this country. That's in terms of the fundamental rights and so on and so forth under the Constitution and under various laws. Now, these laws come into conflict with some of the laws which were applicable in the state of Jammu and Kashmir. In order to protect those laws, what the president did in 1954 order, he incorporated a new article, that is 35A. Incorporated a new article, that is 35A. It is not in the Constitution of India. Obviously, it cannot be in the Constitution of India. It is in the presidential order of 1954. He carved out this Article 35A with the concurrence of the two governments, protecting the employment, the permanent residency, the scholarship. I will indicate that also to your lordships. He protected that as well. Now, this protection, this kind of protection, Article 3, 253, entry 97, all these do indicate I still had constitutional autonomy. It is not that I was completely reduced to a skeleton. Maybe I was on oxygen, but I still was living. I still had that constitutional autonomy in terms of this constitutional position. And I continued with that. Whether this was rightly done or wrongly done, nobody is questioning that wisdom. I mean, that's entirely for the government of the state. And between them, not even the government of the state, but the council of the state. Now see, Parliament is excluded under Article 370. State legislature is also excluded under Article 370. It is the president, the governor, and the council of ministers. That is all. These three are there in Article 370. They can do, undo with the Constitution.
Yes.
My lords, learned judges talk to each other is always mysterious to us. They don't share their views to us, so that we can answer them.
It's the same way.
Positive, negative, or their responses are.
Sometimes the same way when lawyers talks and not necessarily everything is.
So, my lords, I'll just indicate to your lordships now the constitutional autonomy of the state, which still was intact, which is important because that's what we're striving at. That please help us to maintain this constitutional autonomy. What has happened in the past, and also what kind of governments we'll have in future. It is for them to extend these laws to us. But we need our constitutional autonomy. Now, what is it that we had prior to 5th of August 2019? One, your lordship may have a look at this 1954 order, which is the basis of the order because all other orders have subsequently been amended. And I worked on that and I will show the kind of amendments made under various council orders from time to time. Let me begin with 1954 order.
What page, Mr.?
It's volume 3, page 13. Volume 3, page 13.
I think you'll also need to compare it. What is it that was done simultaneously with the Constitution of India? Yes.
To see
That is Constitution Application Order 14th May 1954. This volume area. Volume 3, page 406. General page.
1954. 1954.
Yeah, 54.
PDF page 13.
PDF page?
13.
PDF page 13. In exercise the powers conferred clause 1 of Article 370 of Constitution, the President with the concurrence of the Government of State. Pleased to make the following order. This order may be called Constitutional Application Jammu and Kashmir Order 1954. It shall come into force on the 14th day of May 54 and shall thereupon supersede Constitution Application of Jammu and Kashmir Order 1950. But I may remind here, this is the stage when Constituent Assembly of the state was in session and was making the Constitution of the state. The provisions of the Constitution, which in addition to Article 1 and Article 370, because that is already stated in 370, shall apply in relation to the state of Jammu and Kashmir, and the exceptions and modifications subject to which they shall so apply shall be as follows. The preamble remains as it is. Part 1 remains as it is, but to Article 3, there shall be added the following further proviso. I wait here, also we just have a look. What does Article 3 deal with? It deals with formation of new states and alteration of areas, boundaries, or names of exist. Parliament may by law form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state, increase the area of any state, diminish the area of any state, alter the boundaries of any state, alter the name of any state, provided that no bill for the purpose shall be introduced in either house of the Parliament except on the recommendations of the President, and unless where the proposed contained in the bill affects the area, boundaries, or name of any of the state, the bill has been referred by the President to the legislature of that state for expressing its views thereon within such period as may be specified in the reference or within such further period as the President may allow, and the period so specified allowed is expired. Explanation why in this article clause A to E, state includes a unit territory, but in the proviso state does not include a unit territory. Explanation 2, the power conferred on Parliament clause A includes the power to form a new state or unit territory by uniting a part of any state or unit territory or to any other state or unit territory. Now, my lords, insofar as the order is concerned, Article 3, there shall be added the following proviso, provided further that no bill providing for increasing or diminishing the area of the state of Jammu and Kashmir or altering the name or boundary of that state shall be introduced in Parliament without the consent of the legislature of that state. This is the restriction imposed with regard to the power of the President and the Parliament to do away with the boundaries, the names of the various states. Then, sir, Your Lordship will kindly see 7. Right of citizenship of certain migrants to Pakistan, notwithstanding anything in Article 5, and a person who has after the 1st day of March 1947 migrated from the territory of India to the territory now included in Pakistan shall not be deemed to be a citizen of India, provided that nothing in this article shall apply to a person who, after having so migrated to the territory now including Pakistan, has returned to the territory of India under the permit for resettlement or permanent return issued by or under the authority of any law, and every such person shall, for the purpose of Clause B of Article 6, be deemed to have migrated to the territory of India after the 19th day of July 1948. That Your Lordship will see now what is added to it. यार चलो इसको क्या हो जाता है? हमारा ही चलता ही नहीं है. Article 7, there shall be added the following further provision, be provided further that nothing in this article shall apply to a permanent resident of the state of Jammu and Kashmir who, after having so migrated to the territory now included in Pakistan, returns to the territory of that state under a permit for resettlement in that state or permanent return issued by or under the authority of any law made by legislature of that state, and every such person shall be deemed to be a citizen of India. It's altogether a different provision. The law power to provide for resettlement vests in the legislature of the state, and such person shall be deemed to be a citizen of India. This is the modification made in 7. Then, sir.
Mr. Zapasha, is it because part of the valley, a part of Kashmir remained in Pakistan occupied? Was that the reason for this basis?
So, I could not see.
Was the reason for this, as you are saying this is different, that a part of the state remained occupied by Pakistan? So is that the basis for it? Because there may be people who may be there and may be coming here. Is that the basis for this?
Not only that, there could be something more. Prior to 1947, there were many areas like Gilgit and other areas where the people of the state who were working under the king were transferred. I know a case that happened to me. They were transferred. An engineer was transferred to Gilgit. Then 47 happened. What do we do with him? This provided a method that if you want to come back, originally he was the citizen of this country. If you want to come back, you will do so only under the Resettlement Act, to be passed not by Parliament. In the case which I read to you, also it's the Parliament which is the power. Here, the power vests in the state legislature that he can come back under this resettlement. So all those people, and important thing is, they shall be deemed to be citizens of India. Means they have not abandoned the citizenship of this country by dint of having been posted there or dint of being there prior to the partition of this country, prior to the part having been taken by them. Of course, that would include that also. The people who got separated, who are now with the Pak-occupied Kashmir, of course, the people who still have relationships in Kashmir, those are across the border, they are here. Those are the practical problems faced by the governments, social problems, people's human problems. They wanted to come back. Somebody wanted to die. I know many cases in Kashmir that happened in the High Court. They wanted to die in Kashmir, but they could not come. This Muzaffarabad road was opened. They wanted to come. It then got discontinued for political reasons. So therefore, this kind of a provision only enabled the state legislature to make the law. If they want to come, of course, subject to the conditions of that law. Whether you have voluntarily given up the citizenship of India, then you cannot come. But if you are by dint of a situation and the circumstances, you are stuck up in another place and you want to come back, after the things become normal, obviously a person cannot come when there is a conflict. when peace is returned, you can come back. Nothing is wrong with you, that you never intended to stay there, but because of certain circumstances. So I would say this kind of an power, all I'm today indicating, Your Lordship, is the power, what we call as constitutional autonomy, which I have. It is in that context I'm saying, here I had the power to make the law.
Was large number of certificates issued just as a matter of
That
information
was
free.
sometime that was made. I remember that, Your Lordship, is.
Yes. They issued some of them.
Yes, yes. Actually, then, sir, it has a solar account. It's 2 and 3 does not. And will also kindly see this part 3 of this order. It talks of some of the, I may not read them with regard to Article 16, to whom it will apply for a period of 5 years. That is what is important. And then in 4 and 7, that is the case which went to the Supreme Court in Sampat Prakash and other cases. In clause 4 and 7 of Article 22, for the word parliament, the word the legislature of the state shall be substituted. Now see what is this 22, 4 and 7. Four talks of no law providing the preventive detention shall authorize the detention of a person for a longer period than 3 months, unless an advisory board considers persons who are or have been or qualified to be appointed judge of a high court has reported before the expiration of the said period of 3 months that there is, in its opinion, sufficient cause for such detention. Provided nothing in this subsection shall authorize the detention of any person beyond the maximum prescribed by the law made by Parliament under subclause B of clause 7, or such person is detained in accordance with the provisions of any law made by Parliament under subclause A and B of clause 7. When any person is detained in pursuance of an order made under any law providing for preventive detention, the authority making the order shall, as soon as may be, communicate to such person the grounds on which the order has been made and shall afford him the earliest opportunity of making a representation against the order. Nothing in clause 5 requires the authority making it so as to refer in that clause to disclose fact which such authority considers to be against the public interest to disclose. Parliament may by law prescribe the circumstances under which and the class of cases in which a person may be detained for a period longer than 3 months under any law providing for preventive detention without obtaining the opinion of an advisory board in accordance with the provisions of subclause A of clause 4, the maximum period for which any person may in any class of cases be detained under any law providing for preventive detention, the procedure to be followed by an advisory board in an inquiry under subclause A of clause 4. Now see, sir, what it says. In clause 4 and 7 of Article 20, the word Parliament, the words legislature of the state shall be substituted. So the law of preventive detention can be enacted only by state legislature, not by Parliament. I must make one thing clear here, sir. Some of the laws may be, in a sense, duplicate copies of the central laws. Just duplicate copies of this, maybe full stop, commas, and this. But what is important is the power to make the law. It may be, our state legislature could make the same law as it did, as this preventive detention law is applicable to the rest of the country. But the question is only of power. We say that this power exists only in the state legislature to make the law of preventive detention, and that is how Public Safety Act has been enacted in the state of Jammu and Kashmir. It is that power which matters. Otherwise, laws may be the same. It's possible. Like we had Rabir Penal Code, we used to call it. In the rest of the country, they called it Indian Penal Code. The difference was in the name. But the question was only a power. Our legislature could amend RPC, what we normally use called a Rabir Penal Code, but obviously it cannot amend IPC, Indian Penal Code. Provision may be identical, provision may be same. But what is important to be considered, the power to make that law, the power to amend that law, the power to repeal that law. It is that power which gives us constitutional autonomy. इसमें 30 होगा। पुरानी किताब निकालो, इसमें 30 होगा। 29 इसमें भी मिसिंग है। मेरा उसमें मेरी फाइलों में जरा इसमें निकालो। ये मेरी इसमें कॉन्स्टिट्यूशन ऑफ इंडिया होगा।
Yes.
Sir, then we have this Article 31, which was in existence at that point of time. I have a copy of the original constitution as it was adopted in 1949. You also will not have this Article 31 in the book, which now is because it stands repeal deleted, and we are now instead of 300A, it's a ceased to be fundamental right. But I just read it from the original constitution. No person shall be deprived of his property save by authority of law. No property movable or immovable, including any interest in or in any company owning any commercial or industrial undertaking, shall be taken possession of or acquired for public purposes under any law authorize the taking of such possession or such acquisition, unless the law provides for compensation for the property taken possession of or acquired, and either fixes the amount of the compensation or specifies the principles on which and the manner in which the compensation is to be determined and given. No such law as is referred to in clause 2 made by the legislature of a state shall have effect unless such law, having been reserved for the consideration of the president, has received his assent. If any bill pending at the commencement of this constitution, the legislature of a state has, after it has been passed by such legislature, been reserved for the consideration of the president and has received his assent, then notwithstanding anything in this constitution, it is there? They have it?
Yeah, they.
Okay. Your lordship also has signed that small book.
Yes.
Oh, yeah. If any bill pending at the commencement of the constitution, the legislature of a state has after been passed by such legislature been reserved for the council of president and has received his assent, then not telling anything in the constitution, the law so assented to shall not be called in question any court on the ground that it contains provisions of clause 2. Nothing in clause 2 shall affect the provision of existing law other than the law with the provision of clause 6 apply. The provision of any law with the state may hereinafter make for the purpose and enforcement levying any tax or penalty or for the promotion of public health or the prevention of danger to life or property or in pursuance of any agreement entered into between the government of the Dominion of India or the government of India and the government of any other country or otherwise with respect to property declared by law to be evacuated property, any law of the state enacted not more than 18 months before the commencement of this constitution may within 3 months from such comments will be submitted to the president for his certification, and thereupon if the president by public notification so certifies, it shall not be called in question any court on the ground that it contravenes the provisions of clause 2 of this article or has contravened the provision of subclause 2 of section 299 of the Government of India Act 1935. Now, see sir, this clause 5 has been substituted under this 54 order. It says nothing in clause 2. First is in article clause 3, 4 and 6 shall be omitted. So we have omission with regard to the power of the parliament. That if I pass a law, it was to be reserved for the assent of the president. I don't have to do that. Our state legislature has not to do that. This that's deleted.
Really trying to say is that under the 1954 CO, there were extensive amendments which were made to the adaptations or modifications were made to the Indian Constitution. There are provisions which were deleted, other provisions which were applied with modifications. In fact, interestingly, Article 136 was omitted.
Yes, 136 is omitted. So what I'm trying to
say... So we get that point. We get, what does that lead us up to actually?
What argument is this? When we have a bird's eye view on 1954 order, there are some smaller matters which are matters of internal administration. Then there are some fundamental ones. Like I read, for example, the proviso to Article 13, Article 3, that you cannot alter the boundaries.
Yes.
Now that is a fundamental concurrence between the two governments. I read Article 7 with regard to the permanent residence. That's something fundamental in 54 order. So what I am trying to show is that there are orders which go to the very root of the matter and which continue to remain as they are till date. They have not been diluted. Subsequently, other provisions like 356 subsequently applied, 136 subsequently applied, but they are matters between the union and the state. But then on the broader parameters, the state continue to have its autonomy. That's all I am trying to indicate. By virtue of each and every, I have noted each and every article. It deals with what was the subject matter of the article in the Constitution, and how by the order of 1954, a certain positions, especially for Jammu Kashmir, was carved out.
Mr. Shah, can you just, to sort of summarize, can you tell us on the eve of the CO of 5th of August 19, which were the key provisions of the Constitution to which an exception still existed in relation to Jammu and Kashmir?
So let us say Article 3.
So we can really summarize those because that will give us the net position as on the date.
Very true, sir.
There's two ways of looking at it. We can look at the chipper way, or we can look at it from your perspective, which were the core which was still left intact and which now the abrogation completely, sort of.
It's not with a full chart. That what?
35.
That what was the position on 4th of August 2019, even after application of these constitutional application orders? What was the position as on that date? That's what your lordship wants to know?
Yes. Yeah.
This, some of the articles which I read.
Every one of those provisions which was modified as on 4th of August 19, if you can give us the core to sort of buttress your argument that look, despite the chipping away, this core had remained intact as on 4th of August 2019.
Very true. I can give that. We still had some autonomy. I'll give some fundamental. Let's say entry 97. But we may not go that far also. I can give example of the best example, entry 97. Who had the residuary power? Who had the residuary power to legislate?
Interestingly, both the state list and the concurrent list were deleted in application to the state of Jammu and Kashmir. You'll find that, I just saw it a little while back.
That's what I think it is definitely.
Part 11, see page 16. Page 16 of volume 3, if you're in the same volume.
Yes.
It says in Article 246, the words brackets and figures, notwithstanding anything in clause 2 and 3 occurring, and clauses 2, 3 and 4 shall be omitted. So basically what happened was, in relation to the state of J&K, you had only the union list which was existing. Insofar as it applied to the state of J&K, the entire state list and the concurrent list had been deleted.
But subsequently, you should also see this.
Thereafter, maybe some items in the state list were brought in, maybe the concurrent list was also brought in.
I think you also needs to give me some time. It is also subsequently changed in CO 66. This 246, which was also read, clauses 2 and 3, occurring in clause 1 to be omitted. That was the original one. 3 and 4 is also omitted.
So, really speaking, we therefore take it, Mr. Shah, that we don't have to go through these articles to buttress your point, but your contention is that there was a very substantial degree of autonomy which was reserved to the state as a consequence of Article 370. That was not merely with reference to enacting laws, which we saw in clause 1, but it was also in relation to other provisions of the Constitution, which would not apply unless there was a concurrence of the state.
I thought I would indicate in specifically, one would be a general position of law, that there was a constitutional autonomy with you. What earlier it was, if I put it in terms of quantum, if it was something like 100 grams, but even then I retained 30 grams by the time it was 4th August.
Perhaps, Mr. Shah, what you can do is, maybe without us going into it right now, later on, even after your argument is concluded, you can give us the core areas which had remained for the state as on, the original Constitution.
Specific area, right? I can give.
You can give it to us as of, say, the 1954 order.
Yes.
And then you can give us what still remained with the state as on 4th of August 19. So we can have a comparison.
Yeah,
you can do it in 2 pages, that's all. Don't give us a very elaborate statement. That will buttress your point. So we appreciate it. That's all that we
I had done it my way. I had done it specific article wise. Each and every article, that's what I was trying to show. But if you also want me to give it writing, I will give that.
I think just, on a page, one page of the position as it stood in 1954, 1 page is the position as it stood on the eve of the abrogation. That will really support your submission.
But I'll give that.
So that we don't have to then read individual articles, unless there's something key that you want us to see,
What's important is this, as I said earlier. Why are we aggrieved of 5th and 6th? If nothing was with us. Why are we aggrieved? Why are we for 22, 25 petitions have been filed? There was something with us. I was trying to show what is that was with us. Otherwise, if there was nothing with us, it would not matter. It was an empty formality.
There was something with you, and there was an emotional context of it.
Whatever little, sir, I had with me as a constitutional autonomy, whether they could take it away.
That's why I said 2 things: emotional context and something which remained, actually also remained.
True. What I'm submitting is only, in response to only Chief Justice's observation, that you indicate only what kind of autonomy you had on that date, on 4th of August. I will certainly indicate that.
And even earlier, because that will support your submission.
This was earlier what I had in 54. Is it also willing to go into the question that 54, what you got, and over the subsequent CO orders, what you lost at what stage? I can take one by one your lordships on that. What I lost subsequently, but ultimately it ended up on 4th.
Yes.
But if what you say is on 4th, what autonomy you had to indicate that, I will do that.
On 4th August,
I did have my autonomy.
370 stood, What is that which was with you, which you have been deluded of by repeal of this?
So take it on the face of it, I can say so just from my heart without supporting it. Let's say, because I was a permanent resident of the state, I had my own law. I had own privileges, own rights. Isn't that taken under? It's as simple as that. This will also knowledge. As simple as that. My state could not have been divided into union territories. Isn't that taken away? What Honorable the Chief Justice says, you tell me the solid ones which you lost, not the other things appeal to Supreme Court or otherwise. These are few of the solid ones which come to one's mind. I lost that. I lost my legislature, lost the power to make the laws in respect of those matters where it had the power, maybe little power, but it had the power, particularly entry 97. It made certain laws, it made certain changes, but now that is also gone. Preventive Detention Act is also gone. You'll also have seen in the Reorganization Act how many laws have been repealed. Consequently,
Mr. Shah, to buttress your submission, we are saying something, which will enhance, which will further your submission. Just look at page 16 of volume 3, in case I don't know if you are using the same, we are on the same page.
I'll just have a look.
Volume 3, page 16.
1/6, sir. Just
1/6.
Never mind.
No, somebody can give that.
Yes, sir.
So that we are on the same page.
15 or 16?
Page 16. You've got that middle of the page, part 11. Part 11.
Oh.
PDF page 16.
Yes, sir.
Right? So part 11, right?
Yes, in
A.
Article 246.
In Article 246, the words brackets and figures
2 and 3 of the clause so and so shall be omitted.
and clauses 2, 3 and 4 shall be omitted.
Yes.
In other words, Article 246, which recognizes the power of the state legislature to enact laws on the state list, and the power of Parliament to enact law on the concurrent list was deleted in 1954.
Yes.
Now, just go to page 19, PDF page 19. Go to the 7th schedule, page 19, you will see entry 22, 7th schedule. Just give Mr. Shah the page, Mr. Shankar.
19, yes, no, CO, this is CO 55?
No, 54. We are on CO 54 only now.
Just one minute, I'll show you.
3 pages down, just turn to where the schedules are listed.
7th schedule, yes.
Right. Now, in the 7th schedule, in the union list,
Yes.
just go a little down, item 2, where it says entries so and so, the words interstate migrate and entry 97 shall be omitted. Therefore, entry 97 is completely omitted.
Yes.
Now, go to the last clause of 22B. The state list and the concurrent list shall be omitted.
Yes.
So, the net result in 1954 was Parliament had the power to enact laws with respect to some entries in the union list.
Union list, yes.
The entire legislative domain of Parliament on the concurrent list was obliterated, and the state list was also deleted because the entire power of legislation, the legislative power, was given to the state legislature. This is the autonomy which you are saying,
Yes.
isn't it?
This is what I could specify also what was left. But was question is very extremely important. What was left on 4th of August? I said.
Now we'll go to the 4th of August because that's the part, the chip away there.
What the chief is pointing out in the larger conspectus, what you are saying is 54 reflects the larger conspectus. Larger conspectus is that list 1 as specified, list 2 omitted, list 3 because list 2 already vested with you. Thereafter, as you say, chipped over. So this gives the larger, in support of your argument, the larger context of it.
No, if I am satisfied, not me, your lordships are satisfied that on 4th of August, there was constitutional autonomy, some constitutional autonomy. What was its quantum? How much it was is a matter of detail.
Reflected in it at lunch, almost in the stroke of lunch. One way of our doing it is, after the 1954 order, read every order and see the chipping away process. That will unnecessarily take a lot of time and it will be tedious. What we were suggesting was that you can give us the net position as it stood on the 4th of August 2019. So we'll realize then, we've now seen the 1954 order, which gave a very substantial autonomy. No doubt about it. That point you have made. We need to labor the point further. Now we look at what was the position on the eve of the abrogation, which is 4th of August 19. Because your argument will be that even as on the 4th of August 2019, notwithstanding all the subsequent applications which took place, there was still a core left with the Jammu and Kashmir State Legislative Assembly. So you can give us, like we have now done for 1954, some 3 or 4 examples, and you can put the rest on a piece of paper, just sort of putting it all together.
I can put it entry-wise, this entry, something. That I can do.
But just confine it to the key areas, because that will buttress your point, isn't it?
That's a problem, which is a key area.
No, I mean,
I have some
where the rub lies.
States being together. I mean, unified state is a key area. Who is a permanent resident is a key area.
Right.
I mean, these are the key areas.
So can you just summarize them after lunch for us? Which are the key areas, so that then we can move on to the rest of the argument.
I'll do that. So that
got the drift of the argument. We just thought that we should have some illustrations, which are the key illustrations that will sort of, drive the point home.
So unless your lordship were writing the judgment, would be very specific. Look here, the state still enjoyed its autonomy in respect of A, B, C, D. That's been specific.
Right.
Second would be also would say they did have some.
What has been taken away by the under the provisions which are you on the
what has been taken away? What was left with us? What would be general statement making? Sir, I had, as I try to give example, 100 grams with me. They took 70, 30 still with me. But what was that 70? What was that 30? I thought that I would deal with it in more specific terms. This is taken and this is with me, rather than being general about it. That's what I was trying to.
The only thing is time in all this becomes a little constraint. Now, yes, there was a position in 1954. We've understood your position in 1954. That at various times to time something may have been chipped away.
Yes.
Is there, when and how is not before us. Because that's the post facto situation.
Yeah, very true.
As you also argue. Now, something happened which is under challenge. So, a pre-challenge position for us to appreciate what was the pre-challenge situation which has been deprived in the result of what you have challenged.
Yes. I'm with your lordships.
We have understood your broader arguments on consultation and concurrence. Now we just would like to know what was the residuum which was left on the eve of the abrogation.
What was left of constitutional autonomy? It was in simple language.
As you said,
what is left of constitutional autonomy?
There was something left. What is that something is the only thing we are wanting to know.
All right, we'll just look at it after lunch. And just, one thing to take a look.
Part 6 was not applied.
Go ahead. Mr. Shah, now what is a rough time estimate for you to complete?
I need to still argue, so I have some problems I need to argue.
Should we give you another hour or so? Can we wrap up in an hour so that then the next person?
Actually more than that. Actually more than that. I would repair it might spill over even because I have some more to say.
That's right.
I know all of you have some things to argue. Our constraint is also at some stage things have to end.
Give me that little freedom.
All your ability, I'm sure you can. With all your ability, you can.
Important case for us.
Of course, we understand. That's why we are giving so much of time.
And
of course, Mr. Shah, no doubt about it. Mr. Shah, can we do this? Can we suggest this after lunch? You can give us broadly the themes on which you are going to argue. Just formulate the themes so that we also have a clear picture that how you are now going to unfold the rest of the argument. Just give us the 3 or 4 themes that you're going to argue and show us under that theme. Then we'll know what exactly you are. That will be better. Thank you.
Thank you.
फोटो यार
Testing 1 2 3. Check, check. Check, check. Second. Check, check, check. Audio check. वॉल्यूम अप डाउन करो एक बार. डाउन करना. Check, check.